Thank you.
Are we now live or?
Not yet, not yet. We are not live yet. You will. I'm sorry. I think I disturbed the 1 silent minute. I just filtered out.
Livia gave a thumbs up, so I guess the silent minute is over now.
Okay. Okay. Good. Then we will go live in 3, 2, 1, go.
Good morning and good afternoon. I'm very pleased to welcome you to the first webinar of the Brazilian Supremo Tribunal Federal and the University of Münster. We are very pleased to have this webinar, which is part of a series of 3 webinars over the course of the coming 6 months. And this webinar series is dedicated to kick off a research collaboration between the STF and the University of Münster, about which we are very excited. Now, the topic of today's webinar is COVID-19 and its impact on fundamental rights, which we will discuss both from a Brazilian and a German perspective. But before we start with the program, we will first have 2 welcome addresses. First of Chief Justice Luis Fuchs of the Supremo Tribunal Federal, who cannot be with us today, but who has recorded a video beforehand, which we will see in a moment. And then afterwards, from Professor Matthias Kasper, the Dean of the Faculty of Law of the University of Münster.
Prezados professores, distintos pesquisadores e demais participantes. É com grande prazer e honra que eu abro o primeiro webinar STF Universidade de Münster, Covid-19 e seus impactos nos direitos fundamentais. Este evento internacional, que reúne professores, pesquisadores e juristas brilhantes dos 2 países, é apenas o primeiro passo desta relevante parceria entre o Supremo Tribunal Federal e a prestigiosa Universidade de Münster, materializada pelo acordo de cooperação assinado entre as instituições. Este acordo, celebrado por estas 2 instituições, tem um significado muito especial para o Supremo Tribunal Federal, uma vez que representa o aprofundamento do interesse da Corte no desenvolvimento de pesquisas científicas inovadoras, na construção e difusão do diálogo acadêmico e do conhecimento, levando a Suprema Corte a uma relação mais forte em direção à transparência dos dados e à melhoria da governança e da inovação. Portanto, a assinatura deste documento consolida o interesse mútuo de ambas as instituições em construir um espaço relevante para intercâmbio de acadêmicos e servidores de ambos os lados. Para o Supremo Tribunal Federal, é uma honra poder compartilhar nossos dados públicos, nossos relatórios e pesquisas publicados, além de outros projetos e iniciativas acadêmicas que desenvolvem com a comunidade da Universidade de Münster, especialmente todos os professores, pesquisadores e estudantes da área do direito, da ciência política e humanidades. Como uma universidade de destaque, com reconhecimento internacional por sua produção acadêmico-científica, tenho certeza de que a nossa parceria prosperará e poderemos reunir pesquisadores do Brasil e da Alemanha para enriquecer a produção de conhecimento sobre os temas do desenho das cortes constitucionais, direitos humanos e governança judicial, além de outros temas da ordem do dia. Além disso, é imperativo enfatizar que, através deste acordo, também pretendemos melhorar a internacionalização do Tribunal, na medida em que pesquisadores e funcionários públicos de ambos os lados poderão ter contato com a realidade e o ambiente cotidiano das duas instituições. Portanto, este primeiro webinar surge com a importância de estabelecer um espaço para o intercâmbio de conhecimentos de alto valor de inovação, reunindo, neste primeiro momento, renomados professores constitucionalistas para discutir a pandemia da Covid-19 e seus impactos sobre os direitos fundamentais. Por esta razão, o tema deste webinar se enquadra nos propósitos mencionados, porquanto é exatamente em tempos tão desafiadores que precisamos debater, construir um conhecimento criativo e aprender com as diferentes experiências que ambos os países tiveram em relação ao acesso e à proteção dos direitos fundamentais das pessoas, sempre no afã de garantir que eles não sejam diminuídos ao enfrentar a pandemia da Covid. Toda a comunidade internacional lutou e ainda luta contra este vírus não tão silencioso. E instituições como as Cortes Supremas tiveram que ser cada vez mais eficientes na resposta a esta dramática crise de saúde global. Assim, somente por meio de uma análise profunda do impacto do cenário pandêmico do coronavírus sobre os nossos direitos fundamentais, seremos capazes de proceder a um desenvolvimento qualificado sobre a aplicabilidade da justiça. O evento de hoje reforça a ideia de que as instituições públicas, incluindo esta Corte, devem ter sempre seus olhos e ouvidos abertos para um diálogo atento com os membros da comunidade acadêmica. Este canal de comunicação está presente justamente por meio do intercâmbio de conhecimentos qualificados que fomentam o pensamento e os debates jurídicos de ambos os países. É, portanto, com muito entusiasmo que eu desejo que o primeiro webinar STF Universidade de Münster, Covid-19 e seus impactos sobre os direitos fundamentais, seja muito enriquecedor para todos os participantes e partes organizadoras. E que, ao final, tenhamos discutido possíveis caminhos para a evolução do campo jurídico e de suas instituições. Por isso, convido toda a comunidade acadêmica a desfrutar dos painéis organizados para este evento e principalmente ao público do Supremo Tribunal Federal e da Universidade de Münster, para que se engajem nas atividades de intercâmbio viabilizadas por esta nova parceria. Parabenizo antecipadamente os painelistas, os mediadores e a equipe da Universidade de Münster e do Supremo Tribunal Federal, que não pouparam esforços para tornar possível esta iniciativa pioneira de internacionalização do diálogo com a comunidade científica internacional. Muito obrigado a todos.
Thank you so much, Chief Justice Fuchs, for your warm welcome words. And now I give the floor to Professor Matthias Kasper, the Dean of the Faculty of Law of the University of Münster.
Yeah, thank you. Chief Justice Fuchs, Justice Mendes, Ministros do Supremo Tribunal Federal, dear colleagues, especially from Brazil, ladies and gentlemen. As Niels Petersen mentioned, my name is Matthias Kasper, and I am the Dean of the Faculty of Law here in Münster, and it's a great pleasure to welcome you to this webinar. This webinar is a very important, or better, outstanding event in our academic calendar in this term for two reasons. First of all, the topic of this conference, COVID-19 pandemic and its impact on fundamental rights. When I took up my deanship in spring 2020, the pandemic was still fairly new, and we had hoped to have it behind us in a few months, at least in the summer. And we thought about summer 2020 at that moment. However, today we are close to the second anniversary of the first COVID-19 outbreak in Wuhan. The pandemic is not over yet, but rather the situation is even worse. Brazil has been affected more by the pandemic than Germany. Both countries are fighting still against the pandemic, and here in Germany, it is still the main topic as well. In the last 2 years, we have seen a wide variety of restriction of fundamental rights to deal with the pandemic. Universities and schools were closed over weeks or over months. We had curfews in some German states. Currently, there's a debate about a duty to get vaccinated, at least in some professions, such as nurses in retirement homes. In Bavaria, you have to be vaccinated, recovered from COVID-19, or tested negative if you want to enter your workplace. Moreover, there's a debate that only vaccinated or recovered person will be allowed to visit restaurants, concerts, the cinema, or other cultural events in the next few months. Unvaccinated people will be excluded from social life, even if they have a test that shows that they are not infected by COVID-19 virus. I could continue this list for hours. To put it in a nutshell, the topic of this conference is not only one of the most important issues you can think about at the moment, the conference takes place at the right moment. There's a second reason why this conference is a very important event in our academic calendar. This webinar is the official starting signal for our cooperation with the Supreme Court in Brazil, the Supremo Tribunal Federal. Our faculty is already engaged in an academic exchange with Brazil for a couple of years and is also part of the university's Brazil Center. Nevertheless, the exchange with your Supreme Court and its distinguished judges is not only new, but also a great honor for our faculty. Although our faculty is one of the leading law schools in Germany, with collaborations in many countries, the exchange with the Supreme Court in Brazil is unique. We are a bit proud to be one of your partners, along with Oxford and Harvard. Beyond that, ladies and gentlemen, we are also proud of our alumnus professor and Ministro Gilmar Mendes, who graduated with a PhD from our faculty in 1990. I am looking forward to his lecture and to all the other contributions. I would like to thank my colleague Niels Petersen, who is one of the spiritus rectors of this new exchange, and to my colleague Oliver Lepsius, who will give one of today's lectures and also plays an important role in our network with Brazil. Ladies and gentlemen, and I thank everybody who will give a contribution today. Ladies and gentlemen, I wish you a successful and fruitful conference with an inspiring discussion and new insights. I apologize for not being able to take the whole time in this conference, but our faculty is already looking forward to the follow-up webinars in 2020. Thank you.
Thank you, Professor Kasper, for these equally warm welcome words. With that, I would like to start into the program, and here we are very pleased and honored to have Justice Gilmar Mendes with us, who will give the keynote address of this webinar. And as Professor Kasper mentioned recently, Justice Gilmar Mendes is not anyone to us because he is also an alumnus of our faculty, about whom we are very proud. So without further ado, Justice Mendes, I give you the floor for your keynote address.
Thank you very much. Thank you very much, Professor. Good afternoon, good morning, everyone. It's an honor to participate in this event as an alumnus of the University of Münster. First, I must pay a special tribute to President Luiz Fux, whose administration has provided exchanges and partnerships with leading universities as the University of Münster around the world. This is an initiative that should be honored and welcomed by the members of this court. I also greet the professors from the University of Münster, whom I have the honor to meet in this panel, especially Professor Matthias Kasper, Dean of the Law Faculty of the University of Münster. But before addressing the topic, I would like to say that I have spent my most relevant academic life in Münster under the brilliant advice of Professor Hans-Uwe Eriksen, to whom I am eternally grateful. During my studies, I had the unique opportunity of witnessing the reunification of Germany, that despite being apart for decades, came together even stronger as paragon of excellence in law and in so many areas beyond academia. My studies in constitutional jurisdiction in Germany took place at a time when the debate was still incipient in Brazil. Before the 1980 Constitution, the mechanism of constitutional review were restricted in abstract review to the so-called action of representation of unconstitutionality, which was monopolized by Attorney General. After the new constitution, several entities of civil society, such as political parties and representative class entities, began to hold the power to file actions of constitutionality before the Supreme Court. This transformation has resigned the role played by Supremo Tribunal Federal. We inherited from the German experience the use of the tools of abstract constitutionality control to address latent social and moral issues in Brazilian society. Now I will treat the problem of the what we call in Brazil the jurisprudence of the crisis, if it has to do with the COVID-19 crisis. In the last 18 months, the court has focused on protecting fundamental rights in the face of measures to combat the new coronavirus pandemic. It is no exaggeration to say that were it not for the court's action, the number of deaths in Brazil would today be much higher than the scandalous 600,000 citizens. According to the data of October 11, 2021, the Federal Supreme Court received roughly 10,000 cases related to the new coronavirus pandemic. And in those judicial proceedings, almost 13,000 decisions were rendered. These numbers, available in STF's COVID-19 Actions Panel, show that the court has been active and vigilant in the constitutional review of the pandemic legal apparatus. The Supreme Court carried out the judicial control of the legislation and administrative measures issued within intense political polarization, as we know. As happened in other countries, in Brazil, the social acceptance of measures to restrict individual freedoms was discredited by political groups supporting the President of the Republic. These groups seemed to deny the public health risks of the new coronavirus. Some people railed against some basic public policies, such as the obligation to wear masks in public or the prohibition of mass gathering events. Many argued that closing the stores and the public markets would lead the country into an insurmountable economic crisis. This ideological polarization even reached the scientific discussion. Supporters of the President of the Republic defended the implementation of the unproven early medical treatments, such as the popular medication called chloroquine. Moreover, the measures of social distancing and the isolation recommended by the World Health Organization were considered excessive or unreasonable. Faced with this political context, the Federal Supreme Court developed a proper jurisprudence of a crisis. The judicial review of laws and administrative measures required the court to employ a constitutional hermeneutic approach to understand and conform to the economic and social reality experienced. In many decisions, the court held that the Constitution should provide the excellent discipline of the state of necessity or the state of emergency in many borderline situations. As I have mentioned, in many of these cases, we must remember the famous German expression coined by Konrad Hess, Not kennt kein Gebot. Under this reasoning, the Federal Supreme Court defined the main constitutional questions that arose during the pandemic period, through this open and flexible constitutional jurisdiction. In my presentation, I would like to highlight two themes that have been entirely explored in our recent jurisprudence. First, in the context of Brazilian federalism, the court had to define which public authorities had the legal power to adopt measures to combat the pandemic. This point was crucial because while the President of the Republic defended more timid actions of restriction and social isolation, the state governors were more concerned about the spread of the virus. Second, the court had to draw up the core protection space of fundamental rights restricted by pandemic countermeasures. Discussions on fundamental rights such as freedom of movement, freedom of self-determination, and even freedom of religions were addressed by the court. I will address briefly how the Supreme Court dealt with these two issues and the consequences of this crisis jurisprudence for our Brazilian constitutional jurisdiction. Now, about the allocation of legal powers between federal, states, and cities administrations. On February 16, 2020, the President of the Republic sanctioned a law which established measures to address the health crisis resulting from coronavirus. Since then, some states and municipalities have adopted restrictive measures to prevent the circulation of people and the spread of the virus. Schools and colleges were closed. Stores and shopping centers were barred from opening. Collective events were forbidden, and even people's transportation was restricted. Soon after, a provisional measure and its consequent regulation, a decree, were issued. These regulations sought to establish general rules for facing the public health emergency resulting from the coronavirus uniformly without interruption of activities considered essential. On March 20, 2020, this legislation was again amended to establish measures to restrict the movement of people, stating that the exercise and operation of the public services and essential activities should be protected from restriction, including health care, public safety, and interstate, and international transport of passengers. Given this legal framework, political parties filed before the Supreme Court cases that discuss the legal competence of the executive, of the chief of the executive, of the president of the republic, the state governors, and the mayors of the municipalities to adopt measures to combat the pandemic of the new coronavirus. These political parties were concerned primarily with isolation, quarantine, and the interdiction of locomotion, circulation, activities, and services. The Supreme Court had to decide who would be legitimized to adopt measures facing the public health emergency. In the Brazilian legal system, controversies over federative powers are complex, as it happens with other countries that adopt federalism as a form of states. Doubts about the limits of legislative competence of federated entities often arise. I can remember the lessons of Professor Christoph Degenhardt, who was my professor at the University of Münster. In the event of a conflict, an interpretation should be made considering two premises. First, the intensity of the relationship of factual situation is regulated with the basic structure described in the type of competence under analysis. Second, the primary purpose for which the rule is intended is directly related to the principle of the predominance of interests. In the Brazilian case, on the one hand, the need of standardize the instruments to address the health crisis is indeed relevant. On the other hand, it is necessary to recognize that Brazil is a country of continental dimensions, with regions that require solutions adjusted to their context. It is in this context that the idea of cooperative federalism has been strengthened. The Brazilian federal constitution emphasizes local autonomy by mentioning that municipalities as members of a federative system and establishing it together with the independence of the states and the federal district. The essence of the autonomy contains primarily self-administration, which implies decision-making capacity concerning local interests, without delegation of hierarchical approval, and self-government, which determines the election of the head of the executive branch and representatives in the legislative branch. In this landmark case, the STF then confirmed that the Brazilian Constitution shared the responsibility for health management among all the federative entities. So the measures adopted by the federal government to deal with the new coronavirus do not exclude the concurrent competence or the taking of normative and administrative action by the states, the federal district, and the municipalities. The majority of the justices consider that Article 3 of the law must be interpreted following the Constitution. It means that the federal union may legislate on the matter, but the exercise of this power should always safeguard the autonomy of the other entities. The Supreme Court considered that the federal government's desire to exclude the states and municipalities from adopting one of the few scientifically proven measures could promote the flattening of the coronavirus contagion curve. I should also add that this decision was followed by intense fake news campaigns against the court. Mainly supporters of the President of the Republic began to accuse the court of having prevented him from acting to prevent the spread of the pandemic. This interpretation proved to be highly biased and mistaken. The STF's decision created a valuable space for cooperation between the federal states, which enabled the harmonization of measures to restrict individual liberties. Now about restrictions of fundamental rights in times of crisis. A second thematic issue that the court widely explored refers to the limitation of fundamental rights caused by the measures to combat the pandemic. At the end of 2020, with the beginning of the immunization process, a direct action of unconstitutionality was filed at the Supreme Court that discussed whether the state could adopt compulsory vaccination measures. It was discussed whether vaccination could be mandatory and what sanctions could be imposed on citizens who refused to take the vaccine. The question examined went beyond the contested legislation and concerned more generally the constitutional limits of the imposition of sanitary measures within the scope of public policies to eradicate infectious and contagious diseases. The conflict between fundamental rights was not only between the right to life and bodily integrity and the right to health, rather within the internal scope of latter. The Federal Constitution of 1988 attributed to the right to health a permanent tension between safeguarding an individual legal position and recognizing the state's duty to promote health on egalitarian basis. Article 196 of the Constitution guaranteed a dual nature of the right to health, which is sometimes projected in the absenteeism and the respect for the individual decision of citizen, and sometimes requires the exercise of state's duty of protection. The question inspired the court to revisit the long-standing debate on the subject in foreign constitutional courts. Based on the dialogue with some decision of foreign constitutional courts, the Supreme Court decided that the state may order citizens to compulsorily submit to vaccination against COVID-19, provided for in law from 2020. According to the decision, the public administration may impose on citizens who refuse vaccination the restrictive measures provided by law, acceptable impediment to attend certain places, do school enrollment, for example. Still, it cannot make the immunization by force. It was also defined that the states, the federal district, and the municipalities can conduct local vaccination campaigns. This Supreme Court decision was, I think, fundamental to ensuring the success of Brazil's immunization program. If today we are reaching the mark of more than 122 million Brazilians being fully immunized, no doubt that the court has a positive responsibility in these results. Another Supreme Court decision worth mentioning concerns the exercise of religious freedoms. In early 2021, at the height of what we could call the second wave, several states interrupted the operation of sacred temples. In particular, there was a São Paulo state decree that prohibited any collective spiritual manifestation. This issue was brought before the Supreme Court in March 2021 by political parties identified with evangelical Christian communities who argued that São Paulo state decree had established total restriction on the constitutional right to religious freedom. In a way, this issue has also been the subject of a worldwide debate. After the World Health Organization declared a global pandemic of the new coronavirus on March 11th, several countries began the prohibition or restriction on exercise of collective religious activities. With variations in intensity and the time horizon, these measures sometimes consisted of a total ban of the holding of services and sometimes of establishing intermediate guidelines for the functioning of religious houses. In Germany, in April 2020, on the eve of the Christian Easter festivities, the Federal Constitutional Court rejected the constitutional complaint of a Catholic citizen who claimed that the ordinance of the state of Hesse, which strictly prohibited meetings in churches, violated the right to religion and Catholic conviction. The second chamber of the German Constitutional Court rejected the constitutional complaint and upheld the complete ban on the operation of churches, despite the importance of the Easter festival. In fine, the ban on collective religious events to be constitutional, the German Constitutional Court assessed the plans of the administration of the land of Hesse. In doing so, it did not deny that the fundamental right to religious freedom had been the object of state interference. Still, it pondered that the partial sacrifice of this right did not justify the censure of unconstitutionality by giving special prominence to the acceleration of the COVID-19 pandemic, which was being felt at the time, March, April 2020. Once again, availing itself of the aid of comparative experience, the Federal Supreme Court held that freedom of profess religion in worship is not an absolute right and may be temporarily restricted to ensure guarantees to life and health. In my opinion, my vote, we consider that the right to religious freedom has two dimensions. The internal one, which ensures that people can believe in whatever they want, and the external one, which allows the manifestation of their beliefs. The state cannot restrict the first facet of this right, but the second, yes, especially for the sake of lives and health, citing Article 5.6 of the Constitution. It is important to note that in this case, the court considered factual data and the information on the spread of the pandemic in São Paulo. The vote reporter observed that on March 10th, 2021, the coronavirus contagion curve had presented a significant acceleration in the state of São Paulo and throughout the country. At this moment, an intense spread of coronavirus was noticed homogeneously in all areas of the state. It resulted in a progressive increase of hospitalized patients and raised the occupancy rate of hospitals in the state of São Paulo to the alarming level of 86%. 86%. Based on these factual considerations, the court counted an accurate picture of a public calamity in the health system, unprecedented in Brazilian history. The situation would justify the temporary restriction on freedom of religious worship. Now, my final remarks. The cases discussed are just a few examples of discussions that have been faced by the court. Throughout these last months of the pandemic, we have managed to develop a very solid jurisprudence capable of stabilizing such intense social conflicts of this period. The art of doing constitutional jurisdiction in a time of crisis brings me back to the teachings of another German author who has deeply influenced my studies, Professor Peter Hebel. By conceiving constitutional law as a discipline directly linked to the culture, philosophy, and contemporary reality, with which is it connected, he believes that all situations related to the constitutional test cannot be interpreted in isolation. For Professor Peter Hebel, legal thinking of the possible is the expression, consequence, presupposition, and the limit of an open constitutional interpretation. It's about thinking from and in new perspectives and realities, asking oneself, what other solution would be feasible for a given situation? To that extent, and this seems to be one of critical consequence of the orientation adopted by Hebel. A constitutional theory of alternatives can become a constitutional theory of the tolerance. Hence, one can also perceive that alternative is a possible thought is relevant, especially in the interpretative event, in the choice of the method as verified in the controversy over topically as productive force of interpretation. I believe that in this period, the Brazilian Supreme Court has built a true jurisprudence of tolerance. In a time of democratic crisis, this is perhaps a rare experience of constitutional court that opposed the ignorance, the denial of science, and the lack of social solidarity that was advocated by extremist groups. I am convinced that the court has fulfilled its role. More than that, the tribunal has strengthened the bonds of democratic order that, even if recent, bears fruit in the solidity of its institutions. Thank you all. Vielen Dank.
Thank you so much, Justice Mendes, for these very interesting insights into the practice of the Brazilian Supreme Court in striking the balance between protecting health on the one side and protecting liberty on the other side. And what I found particularly striking is how you made use also of comparative insights, of judgments of other courts in order to find a good solution for the problems before you. Thank you so much again. Now we will hear two different perspectives. Again, one Brazilian perspective, but not from the court, but from academia, with Professor Vera Karam-Deshwari from the University from the Federal University of Paraná, and then a German perspective from Professor Oliver Lepsius from the Faculty of Law of the University of Münster, and both speakers there will be a comment to both speakers. I will comment on the presentation of Professor Karam-Deshwari, and Professor Ingo Wolfgang Salet will comment on the presentation of Oliver Lepsius. I also invite the public to ask questions. There is this Q&A function. Unfortunately, I cannot invite you to speak in public, but if you have questions to any of the speakers, please use this Q&A function to write your questions, and then either the speakers or the commentators may address them either orally or in writing. With that, I give the floor to Professor Vera Karam-Deshwari, who will now give us some insights on the topic from the Brazilian perspective.
Good morning, good afternoon, everyone. It's an honor to take part in this webinar with STF and the University of Münster. I'd like to thank Brazilian Supreme Court Chief Justice Luis Fux and the coordinator of the Judicial Research Division, Lívia Gil Guimarães, for the kind invitation to take part in this webinar. I'd like to thank the University of Münster. My talking will be on the COVID-19 and its impact on fundamental rights that I rather address as human rights. COVID-19 has been a test of societies, of governments, of individuals, and respect for human rights is fundamental to the success of public health response and recovery from the pandemic. This is especially due to the fact that COVID-19 pandemic and the related measures and restrictions brought human rights under a great tension all over the world. In Brazil, the pandemic exposed the bulk of good public constitutional health policies and services and the weakness of government, especially federal government, to make them effective and accessible to everyone. The pressing need of these policies is even more urgent to the most vulnerable and marginalized populations, such as indigenous peoples, people in custody and in institutions, LGBTIQA+ community, health workers, women who find themselves in the eye of the storm. Unfortunately, the consequences of the pandemic will last and human rights may well suffer aftershocks. To tackle the virus and to mitigate the effects of measures designed to halt the spread of COVID-19, it has been necessary a consortium of action from government, civil society, individuals, and institutions, public and private ones. So it's about time for solidarity and cooperation in all levels. Under international covenant on economic, social, and cultural right, everyone has the right to the highest attainable standard of physical and mental health. So governments are obligated to take effective steps for the prevention, treatment, and cure. Under Brazilian Constitution, as Justice Gilmar Mendes already said, everyone has also the right to health, and the government has the duty to provide health services by means of public health policies. There is an opinion written by former Brazilian Supreme Court Justice Ellen Grace that says the right to health is an available constitutional prerogative, guaranteed through the implementation of public policies imposing on the state the obligation to create objective conditions to enable effective access to such a service. The right to health is closely related to and dependent upon the realization of other human rights, including the rights to food, housing, work, education, human dignity, life, non-discrimination, equality, the prohibition against torture, privacy, access to all information, and the freedoms of expression, association, assembly, and movement. These and other rights and freedoms address integral components of the right to health. For this very reason, even in a situation of exception, in a state of emergency, generally speaking, such as the COVID-19 pandemic, and in face of its circumstances, restrictions taken by governments in all levels, federal, state, and local level, for reasons of public health or national emergency, must be lawful, necessary, and proportionate. Thus, any measures taken to protect the population that limit people's rights and freedoms must be limited in duration, and any curtailment of rights need to take into consideration the disproportionate impact on the specific populations or marginalized groups. My presentation stresses two cases in which the impact of COVID-19 pandemic on human rights in Brazil turned on violations due to federal government action and non-action, that is, omission. Case one has to do with freedom of expression and academic and scientific freedom, and case two has to do with indigenous population and their health care. Case one, under international human rights law and under Brazilian constitutional law, the government has an obligation to protect the right to freedom of expression, academic and scientific freedom, including the right to seek, receive, and impart information of all kinds. Permissible and eventual restrictions on freedom of expression, academic and scientific freedom for reasons of public health may not put in jeopardy the right itself. In the case of COVID-19 pandemic, the government, I'm referring to the Brazilian government, but it could be any other, is responsible for providing information necessary for the protection and promotion of rights, beginning with the right to health and other rights, such as freedom of expression, academic and scientific freedom. It's a core obligation to provide to provide education and access to information concerning the main health problems in the community, including methods of preventing and controlling them, that is, health policies to combat spreading the virus. A rights-respecting response to COVID-19 have to ensure that accurate and up-to-date information about the virus, access to services, service disruptions, and other aspects of the response to the outbreak is readily available and accessible to all. This has to do with educational, academic, and scientific institutions, their capacity to provide knowledge, science, and information based on them, and the capacity of their researchers, professors, scientists to speak up and to be heard. Brazilian government has failed to uphold the right to freedom of expression, academic and scientific freedom, taking actions against journalists, academic scholars, and healthcare workers. This ultimately limited effective communication about the onset of the disease, put forward a set of intimidating procedures against all who disagreed with Brazilian government policies, such as the use of the so-called COVID kit, consisting of a cocktail of drugs, chloroquine, azithromycin, and ivermectin, without any scientific evidence of its efficacy, etc. And even worse than, the COVID kit has been recommended against the protocols and recommendations of the World Health Organization. On the one hand, Brazilian government did propaganda to enforce the use of COVID kit without any evidence of the effectiveness regarding the one-size-fits-all treatments. And on the other hand, the Brazilian government has persecuted scientists, professors, researchers, and journalists who denounced the precariousness of the so-called early treatment, irregularities in the vaccine purchases, and a kind of deliberate death policy agenda. Inconsistent messages from public officials at federal level, especially about treatment and the effectiveness of drugs, against the use of masks, against state and local policies of locking down, even messages denying the number of deaths, has diluted the impact of public services announcements about proper hygiene and social distancing. Scholars from prestigious universities and centers of research who manifested their disagreement with federal government, mainly with the president, have been orally attacked and sued by the Brazilian general prosecutor. Those who are in favor of science and scientific evidences were sued by those who daily addressed false and misleading information to the people and expressed anger against his opponents. Instead of having fully respect to the rights to freedom of expression, academic and scientific freedom, the federal government has restricted them as well as the access to information. Instead of ensuring that the information it has provided to public regarding COVID-19 is accurate, timely, and consistent with human rights principles, the President of Brazil, the Secretary of Health, and other federal public officials attacked those who did it. Last February, a well-known scientist, epidemiologist, and former dean of the Federal University of Pelotas, called Pedro Halal, was informed by the Comptroller General of the Union that he could lose his job because of his criticism of presidential decisions about COVID-19 pandemic. Mr. Halal, who coordinates one of the larger COVID-19 epidemiological research projects in Brazil, called the president negligible because of the president's anti-vaccination discourse and his political interference in the selection of the university deans. Like Pedro Halal, other scientists, researchers, professors, public intellectuals who criticized the president and his death policy, so to speak, in conducting the pandemic, have been persecuted and threatened. All information about COVID-19 should be accessible and available in multiple languages, including for those with low or no literacy, and for those who have their own native language, such as indigenous peoples. At this point, I move to the second case of my presentation, which has to do with the government non-action or omission in protecting indigenous peoples and their communities against the spreading of the virus. These people who are already in positions of vulnerability or marginalization in society have suffered enormous loss. Case 2. The right to indigenous health is related to the realization of other human rights, such as the right to self-identification, the right to consultation, and the right to territory and culture. The right to health of indigenous peoples has lacked government support since the beginning of the pandemic. The inequality of treatment and access of indigenous peoples to public policies and services was crystal clear. Under international human rights law and under Brazilian constitutional law, indigenous peoples are protected and the government has an obligation to give them health support, no matter their land tenure situation. Even those who don't live in their villages must receive health support. It's unconstitutional to not extend the right to be assisted by the indigenous health subsystem to indigenous peoples not living in the villages. It also violates the Indigenous and Tribal Peoples Convention of International Labor Organization. In 2009, Brazilian Superior Court of Justice decided that the subsystem of indigenous health care must serve to all indigenous peoples individually or collectively and without any discrimination in national territory. Since the beginning of COVID-19 pandemic, illegal encroachment, invasion on indigenous lands has increased. The Brazilian government, instead of acting to prevent it, supports it, and a kind of genocide, so to speak, is taking place, in my opinion. The federal government does not care about or respect the way of life of indigenous peoples who are socially and epidemiologically vulnerable. COVID-19's lethality rate for indigenous peoples is 9.6, while for the Brazilian population in general is 5.6. This is due to their immunological indefensibility and vulnerability regarding their ways of life, the lack of government care and services, and the increase of encroachment in their lands. Yanomami, Caripuna, Urueu, Uauau, Kayapó, Ararioroboia, Munducuru, and Trincheira Bacajá lands. This state of affairs implies the violation of their basic human rights in three ways. First, the right to life and the protection of their way of life. Two, the right to an ecologically balanced environment. And three, indigenous land as union public goods. A sad and serious consequence of these actions and omissions by the Brazilian federal government was the extinction of an entire ethnic group, the Zuma ethnic group, which happened due to COVID-19 and the lack of protective action by Indigenous Peoples Protection Agency, FUNAI. Unfortunately, even the judiciary has not been cooperative in this matter. There is a type of constitutional lawsuit at the Brazilian Supreme Court, ADPF 709, pending of decision, in which all evidences show that in keeping these policies of death towards indigenous people by the federal government, there is an imminent risk of extinction of entire ethnic groups. Despite federal government negligence and wrongdoings, Brazilian Supreme Court has postponed its decision at ADPF 709, frustrating a possible response in terms of installation of sanitary barriers in more than 30 territories where indigenous peoples live in voluntary isolation or recent contact, as well as the removal of invaders from the Yanomami, Caripuna, Urueu, Uauau, Kayapó, Arariroboia, Munducuru, and Trincheira Bacajá indigenous lands. And I I'm finishing my presentation. I come to the end of my presentation. It's noteworthy that there are two precautionary measures at the Inter-American Human Rights Commission against Brazil concerning COVID-19 pandemic and the health of indigenous peoples. The Commission requested that Brazil acts in order to protect the rights to health, life, and personal integrity of the members of the Mundukuru and Yanomami and Yukiwana indigenous peoples, respectively, implementing with a culturally adequate approach prevention measures as regards the spread of COVID-19, as well as providing them adequate medical attention in terms of availability, accessibility, acceptability, and quality in accordance with the applicable international standards. These two cases are examples of the impact of COVID-19 pandemic on human rights in Brazil from the viewpoint of their violations due to federal government actions and omissions based on negationism, on fake news, and on censorship towards journalists, scientists, professors, health workers, or who else speak up against it. Ailton Krenak, an indigenous movement leader of Krenak ethnicity, once said that we have to have dreams to postpone the end of the world. So it's a good start. Thank you very much.
Thank you so much for your very illuminating presentation, Professor Karim Deshwari. In my comments, I would like to first take a step back before I address in particular the two cases that you described and discussed. Now, the COVID-19 pandemic has seen very different responses from government. So we have on the one hand very drastic restrictions of individual liberties. I guess China is probably the most extreme case in this regard, to very liberal responses with no restrictions and the denial of the existence of COVID-19. And here I would say, I mean, there are many candidates for that, but probably Tanzania is the most drastic case in that respect. And we always see that there's a tension between, on the one hand, protecting human health and individual liberties, and between these two poles, China on the one hand and Tanzania on the other hand, we have seen governments taking very different positions, and probably can also say from the legal point of view that there are various legitimate responses by government, so that there's not just the one way which is legally appropriate. Now, the two situations that you pointed out in your talk, Professor Karim Deshwari, I think there you highlight a situation where it clearly seems necessary that the law sets a limit to government action. First, in a way where government restricts individual liberties, and second, in a way where government doesn't protect human health sufficiently. And I agree with your normative evaluations. However, I would like to add a few thoughts to these two case studies that you brought. So first, I guess we certainly all agree that the freedom of expression is violated when the government tries to suppress important, potentially life-saving information, for example, by threatening individuals to dismiss them from their jobs if they continue giving these informations. But I would like to add an additional layer of complexity just as a food for thought, because just let's take the opposite viewpoint and look at government responses if the government tries to suppress disinformation about the pandemic, about medical cures, about the safety of vaccine, of which we have seen plenty, not just in Brazil, but I guess all over the world. And this is a serious problem that we are facing as well here in Germany. Now, what role can government play in addressing this disinformation? And if we agree that there is a legitimate role for government to suppress and to fight this disinformation, then of course, two questions arise. First is, where's the limit? So how far can government go in trying to limit disinformation? And the second, of course, is how do we actually distinguish valuable information from disinformation? In the academy, we have come to accept certain standards of what is true information and what is not true information. We have accepted certain academic standards, but these academic standards do not always translate well into the public discourse. It's precisely this ambiguity in the public discourse, the lack of objective signals for distinguishing right from wrong, that today's populists exploit so masterfully in promoting their dangerous propaganda. And I believe that we have to find ways to distinguish actually valuable information from disinformation, even though I guess in our circle we all agree of what is the one and the other. But in the public discourse, we also have to find ways to distinguish the one from the other. And I think we haven't really done a good job in doing this. Now, coming to your second case study, where you highlight the dramatic situation of socially vulnerable groups. You highlight in particular the situation of indigenous peoples, but there are other vulnerable groups, ethnic and religious minorities in general, prisoners, the poor, all groups who have suffered disproportionately in this pandemic, and not just in the first waves of the pandemic, but even today where vaccines are available in many states to prevent serious illness. And even here, we have seen that these socially vulnerable groups still are at a disadvantage. They have lower vaccination rates for many different reasons. Often they, in cases where vaccines are still scarce, they don't have the right connections, or they don't have access to the proper information, or maybe because they just distrust, for good reasons, authority, and therefore distrust the vaccines in general. So there are several hurdles that lead to these socially vulnerable groups being disproportionately affected by the pandemic, even today that in many cases we have vaccines available. And therefore, I share your inclination that courts have a specific role to protect these vulnerable groups. However, I believe also in this case, courts face a dilemma. So how do courts actually determine the positive measures to take? So if they stay vague and just give a very general mandate to government to take action in order to protect public health, then these judgments are probably easy to circumvent, because government can always say, well, we did our best effort actually to protect public health. If governments get more concrete and mandate certain specific actions, then probably courts are outside their comfort zone, because they have actively to engage in politics, which is not a position courts traditionally take, and it's also not a position, or it's probably also a position where they can easily be attacked as political actors. and therefore it's not a position that courts might be comfortable to take. So I accept your normative challenge, but I believe that it's not easy to resolve this conundrum, and I also don't know an answer for this. I just want to bring it up and just show how thought-provoking your presentation was, and thank you very much again for your very thought-provoking presentation. Now I have two questions from the audience. Maybe I just read them aloud. I guess we have 5 minutes before we go to the next presentation. Professor Karim Deshwari, thank you very much for your brilliant presentation. Since my field of profession is criminal law, I wonder whether there's a debate about the potential criminal liability of political decision makers in Brazil. For instance, you spoke about officials' omission to take measures against the pandemic and even the extinction of entire ethnic groups. Could this be a basis for homicide or even genocide accusations? And then I have a second question. The misinformation of the effects of the pandemic affected the public health. How far is this misinformation included in freedom of speech or opinion? So I'm not sure whether the second question is addressed. Probably they're both addressed to you. So if you want to briefly answer these questions, if you like.
Thank you very much. Thank you so much for your comments. I would have a few other comments on your comments, so let's do it maybe in another opportunity. I wrote down all your comments. I would like to send you my comments, my opinions on your comments. I'll write to you.
Please do. I would be very interested in your opinion.
Yeah, especially this what you pointed out, the difference between public discourse, political discourse, and the populist discourse concerning especially the pandemics. Well, but I'll move to the two questions. Thank you, Mr. Frank Zimmerman. In my opinion, not just my opinion, but few colleagues have the impression that what we are seeing at this moment in Brazil towards indigenous peoples is a kind of genocide, or generally speaking. And I believe that there is a way there is a way to to ask the responsibility for those who are doing that. But it's hard to say, but we are in a very fragile moment in our constitutional democracy. So even the measures that we could take towards the responsibilization of these authorities at this moment are not working very, very well. I'm not talking about the judiciary. I think that the responses given by the judiciary right now are the better ones, are the best ones. But on the other hand, concerning the executive branch and the legislative branch, to ask the responsibilities are somehow tough right now. Well, the second question, I would say, I'm not very sure if misinformation is included in the freedom of speech or opinion, because the the exercise of one right cannot doesn't mean it's violation. That is, the right to freedom of expression cannot mean it's violation, cannot mean the suppression or the misinformation of the expression. So in my way, the misinformation, it's not included in the freedom of speech or opinion. It's exactly the opposite. It's the violation of the freedom of expression. Thank you very much.
Thank you so much, Professor Karam Deshwari. And now we come to our second block. We look at the situation in Germany. And first we have our speaker, Professor Oliver Lapsius, who is a professor of public law at the University of Münster. And then we have his commentator, Professor Ingo Wolfgang Salet, who is professor and coordinator of the postgraduate program in law at the Law School of the Catholic University of Rio Grande do Sul. Professor Lapsius, you have the floor.
Thank you, Niels, and a warm welcome also from my side to all of you who attend. Well, my presentation will bring a rather different picture of legal issues of the pandemic compared to the excellent paper by Professor Karam Deshwari. Perhaps I may sum up the issues in saying that Brazil seems to be a case of underprotection against COVID-19, and I don't know whether Germany is a case of overprotection, but at least our legal issues are more in the realm of an overprotection issue, and definitely not in an underprotection issue. So that's already very interesting in a comparative perspective. I very much focus on limitations of civil rights and how the courts dealt with them. So it's a little bit an empirical paper which I tried to give after 18 months of experience with rights review in Germany so far. And I try to sum up a little bit the experience that we have collected so far and try to evaluate this experience. My paper is organized in two major parts, and then there's a little third part where I draw some conclusions. The first part deals with the political measures and their social effects, hence it's a more descriptive part. The second part then comes to the legal questions of judicial review, scrutiny issues, what the courts actually did, and then final third part, briefly, some conclusions. Let me start with a more descriptive part. The pandemic laws in Germany introduced an enormous amount of limitations to civil rights. I sum up a little bit. There were limitations of individual contacts, the prohibition of religious services and assemblies, of meetings, political parties, and private associations. Then we witnessed the closing of kindergartens, schools, universities, libraries, museums, theaters, sports facilities, trading shops, never actually producing industries, but the trade businesses were affected. Craft shops were not affected. But then the closing of trade fairs, restaurants, hotels, the leisure industry, so to say, traveling for private purposes was prohibited. We had, our dean mentioned that earlier on, partially curfews, general curfews during daytime, and night curfews. So these political instruments affected nearly all basic rights of the Constitution, except, and that is an interesting distinction to Brazil, except freedom of expression, that was not affected in Germany, and the freedom of communication, which goes along, of course. So there we see, again, a different picture in the legal situation in our two countries. So we then talk in Germany of a time of the most excessive rights limitations in the history of the Federal Republic of Germany. And these intense infringements showed very different social effects. And this is, I think, very interesting for a lawyer then. Everybody was affected in his or her private affairs, namely the restriction of individual contacts in the private sphere and the public sphere, the limitation of contacts to the members of the same household. So that affected everybody. Everybody was also affected in leisure activities. Leisure activities became practically impossible. One could not use sports facilities any longer, not visit restaurants, museums, no cultural activities whatsoever. And private traveling that required accommodation was also impossible. However, only some were affected in their businesses and in the exercise of their professions. Shop owners, on the one hand, could not run their shop, but because they could not open the doors, they only could run their shop with online customers. Restaurants could deliver meals outside, but must not host customers. So they were partially limited. Some professionals, however, couldn't do anything. They were completely limited. We may talk about musicians. Apart from rehearsals, they could not perform. Actors, broadly speaking, all performing artists were unable to exercise their profession. A third group of people, however, was not affected at all. They could work almost normally. We may talk about blue-collar workers, white-collar workers in offices, construction workers. So most of the people did not see major infringements in their professional world. The limitation of civil rights hence shows very unequal effects. Everybody was affected in the private sphere and in the social sphere, but not in the professional sphere. We get quite different pictures if one looks to the aggregated social effects of these rights limitations. Two examples: women generally were more affected than men because they had to take care of their children who were locked out of school and sat at home, partially being kept busy by homeschooling via computers. And children generally are regarded as being the most affected group in Germany because their whole infrastructure was closed and their life was practically limited to their family home, with all consequences and inequality issues. And let's not forget students as a particularly harmed group as well, because universities and libraries closed, no leisure activities were possible, restrictions of private contacts with the members of one household affected students much more than families because they were living alone, since there was no second person whom they were allowed to have a contact with. And student jobs were canceled because the businesses were closed. So we see that there were major infringements with very different social effects. So far, one can say that anti-pandemic laws lead to inequality issues in the first part. Let's look to the law, second part of my presentation. In 2020 and 21, thousands of persons filed lawsuits against these limitations. So we have seen a mass of civil action in courts attacking the rights limitations. We really speak of thousands of lawsuits. However, only a very limited number of these cases were successful, seen from the position of the claimants. Generally, one can conclude that the German courts accepted the civil rights limitations broadly. Or to put it differently, civil rights did not prove to be a sharp instrument against rights limitations in the pandemic. For us in Germany, that is a remarkable outcome, since the basic law, the Constitution of Germany, usually is considered as being a very rights-oriented or even rights-driven constitution, and the Federal Constitutional Court in Karlsruhe claims itself as being a citizens' court. What may be the reasons for this gradual ineffectiveness or irrelevance of rights reviews? 3 thoughts on this. First, most of the rights limitations were practically not reviewable. There is no right against the lockdown of leisure or social life. The closing of schools or of universities literally does not infringe a peculiar constitutional right. The courts basically dealt with infringements in the right to profession. That is Article 12 of the German Basic Law. Hence, economic liberties were those most often dealt with in court procedures. Economic liberties. The social effect of the closing of those businesses, no leisure life, if a restaurant is closed, everybody is somehow hindered in the private leisure life. The social effect of these economic infringements were not conceived to be a violation of a civil right, because there is no right of a protection of the social environment of leisure facilities. We discuss rights issues mainly in economic terms, not with the social regard, not as equality issues. Without 3 exceptions in the case load, exception 1 and 2 go back to very early injunctions of the Federal Constitutional Court, who quickly restored the liberty of religious service and the freedom of assembly. And the 3rd exception comes out of administrative law injunctions, where shopkeepers won their cases before administrative courts because they were treated unequally compared to other shop owners, when some shops were allowed to reopen their business according to specific square meter requirements of the size of the shop, below 800 square meters, above 800 square meters. And in such cases, the administrative court said there is no rationality to differentiate with a number of 800 square meters. This is unequal treatment. So those are perhaps the 3 exceptions where civil rights issues then turned out to be successful in the court proceedings. But generally, the civil rights provisions do not cover the essential limitations of the people. And that is surprising news for a civil rights-oriented constitutional order that claims to establish a gapless protection of fundamental rights. The second point is proportionality generally did not furnish a sharp justification limitation. Almost no court decision came out with proportionality claims. Why did proportionality prove so irrelevant or ineffective? I see two major points on this. First of all, it was unclear what were the concrete purposes the laws in question pursued. Politics often presented three goals that somehow went along and contributed, but also rivaled, namely the protection of life, the protection of individual health, and the general protection of the health system. And usually these three goals were put together rhetorically as if they were one single goal. But that's obviously not the case. Whether one protects individual life, it has a different justification level in contrast to a measure that only protects the public health system. Proportionality, hence, was structurally unbalanced because there was no clear presentation of what were the constitutional rights or constitutional values, the specific measures intended to pursue. And the second point is factual issues. Whether a means is suitable or necessary requires for judicial scrutiny a factual assessment that was often difficult to make because the authorities did not know much about the disease, the spread of the disease, the ways of infection. And hence, lacking medical evidence and lacking virological knowledge made proportionality review difficult, if not impossible. All means seem to be suited and necessary, at least in the first period of the pandemic. The limitation of less restrictive means were basically never taken into consideration by the courts. That means generally proportionality was not suited because of lacking factual knowledge and ambiguous justifications of the laws. The third point is the following. The third point why constitutional review of rights violations practically failed, namely the fact that the courts decided almost all cases by preliminary judgments. Preliminary review, however, does not apply a hard look. Preliminary review is under time pressure and addresses the legal issues only with a very limited scope of review. It also balances factual alternatives rather than rights. So far, we do not have a single final decision of the Federal Constitutional Court on pandemic issues. There are only preliminary decisions. And among the cases of the administrative courts, there still is only a handful of final judgments. So we are waiting for a whole bunch of final judgments still to come. Conclusions, what could one do? So what are perhaps for academia the interesting outcomes of this 18-month experience? There are obvious gaps in the rights culture. Maybe we have to activate the essentiality provision in Article 19.2 of the Basic Law. I know in Brazil, you're very familiar to the work of Peter Heberle, and Peter Heberle's dissertation was already based on that provision that was actually never taken up by the Federal Constitutional Court. Maybe the time has come to activate that provision, would be one proposal. Another issue is to extend personality rights or to invent new rights that protect privacy aspects. It would be highly problematic, however, if we end up, when we deal with a pandemic, with checking only economic rights at the cost of neglecting social harm and social equality. And that's the situation how it looks at the moment, where it's basically only focusing on economic rights and not on social inequality issues. And that, of course, would be very harmful to the legal system in general. A second proposal would be to sharpen proportionality review. And I would say mainly in urging the authorities to give more precise justifications for their measures. And finally, one should critically overlook the proper substantial standards of preliminary review. So those would be, for the time being, my 3 proposals for further academic endeavor on these issues in Germany. Thank you very much.
Thank you, Oliver. And now we have Professor Zalet, who is commenting on Professor Lepsius' presentation.
Okay, sorry. Okay, thank you all, and I especially thank and want to greet the promoters and organizers of this webinar in the name of Chief Justice Louis Fuchs, Professor Dr. Matthias Kasper, and Professor Dr. Niels Petersen. I also thank Livia, Guilherme, and Patrick for all the support, and greet my panel colleagues, Justice Gilmar Mendes, Professor Vera Caran-Lixueri, and Professor Oliver Lepsius. I will start with some general comments, focusing both on Oliver Lepsius' comments, and I will add some personal remarks if possible. The first observation I have related to Oliver Lepsius' comments, really fantastic presentation. I also read his paper translated into Spanish on this topic before the presentation. I would say that even in Brazil, we had and we still have a tension between underprotection and overprotection. One can see this clearly even when we consider some disputes, really direct disputes and very heavy disputes between municipalities and state governments. State government restricting more some rights in order to protect health and personal physical integrity and life. On the other hand, municipalities boycotting and trying to be more flexible because of course the big pressure coming from the society, from economic actors, and so on. So we have a constant shifting between overprotection and underprotection, I would say. And it is exactly in this context I underline Justice Mendes' statement that the first and very important decision of our Federal Supreme Court was to try to coordinate, at least to some extent, this tension between the federal government, the state governments, and the municipalities, trying to induce, to a certain extent, cooperative federalism, but this tension is clear between underprotection and overprotection. Another comment I will address is that I would say in Brazil, also the measures didn't affect freedom of expression and communication. What we have had is that coming from some sectors of society, we have really a lot of fake news and hate speech and even apology of military intervention and dictatorships. But this is not coming from officially from our, it's not being enacted in general through legislation and administrative acts, but it's more coming from informally from sectors from the government, federal government, but informally, and of course, more through social media and so on. And our federal Supreme Court at the moment has not a really leading case related to fighting fake news and disinformation, though some decisions have been taken, especially related to apology of dictatorships and direct aggressions to democratic institutions. What we had is an attempt from the federal government to regulate social media, but at the same time, excluding from this regulation the possibility for social media to moderate hate speech and fake news. So this was an attempt, but the Supreme Court in a preliminary decision fulminated this attempt. It was a federal government's executive measure, and the Congress sent this project back to the executive. Now we have a bill of law being discussed in Congress related to fake news, one specific one, and to moderate content regulation from social media, but it's still being discussed. We don't have a specific measure, in fact, related to this domain. And our Supreme Court is very strict and has been supporting strongly preference position of freedom of expression in Brazil in several cases, even now during the pandemic. So this I maybe can be a little different than in, or it's similar than in Germany. I think what another aspect Professor Lepsius has shown is that in Brazil, as well as in Germany, a parallel legal system was created, even not being a formal state of exception or emergency. In Brazil, we have two exceptional states, emergency and the state of siege. They are strictly regulated in our federal constitution. But what we had was a legal state of calamity. That's the name we used, legal state of calamity, which was enacted in all levels of our federal state. The difference is, and this is maybe important to say, that the restriction of fundamental rights we had during the pandemic, authorized by these legal measures, are by far higher and reach beyond the possibilities of restriction that they are previewed in our constitution for the state of siege and the state of emergency. So, like our research has shown in Germany, almost all fundamental rights was affected by these measures. The difference is, and this is important as well for the comparative approach, that we have in Brazil a large set, as you know, of social, economic, cultural, and environmental rights. And these rights has the same status, the same constitutional regime of protection than civil and political rights. So they are direct, binding, and direct applicable norms. They are limits to the amendment power of Constitution. And this, of course, makes a huge difference when the court comes to balance the conflict between civil rights protection and, of course, the promotion protection of health and even of the right to access to education, environment, and so on. So this makes a difference in the process of balancing. And of course, in this sense, our court comes to maybe different results than the German Federal Constitutional Court usually comes in these cases. Of course, we have even a wider set of issues being decided by our court, the number of decisions Gilmar Mendes mentioned at the beginning, and they go far beyond the measures we can say that has been the fact in Germany or even other European countries. Especially we had related to the social effects, some similar social effects, of course, for women, for students, and even for commerce, etc., access to leisure and so on. But we had also a very strong increase of social inequality, increase of concentration of wealth in Brazil, a strong increase of unemployment, a strong increase of informal work, labor, and also several attempts, several measures were addressed to reduce, to flexibilize labor laws. I think this is also, in my opinion, a difference that should be underlined. The phenomenon of judicialization of health or health litigation, of course, also increased a lot during the pandemics. And here, similar to Germany, and it's a concern, and we have several critics addressed to the jurisprudence of our court. They are not new, but they increased in the last 18 months, is the certain lack of self-restraint of our Federal Supreme Court, a number of highly invasive decisions of administrative and legislative competence, especially executive competences, and the way the judicial control has been undertaken. In two cases, I will highlight two cases. One, what I can translate into English properly, I think, it's the legality principle and the erosion of the legality principle, because a large set of the measures enacted has been enacted through to laws, to statutes, but through administrative acts, and to large extent not directly authorized by laws. And in this sense, our Federal Supreme Court has been historically a little bit indulgent with the legality principle and its requirements. In German, we would say Gesetzesvorbehalt, Reserva, delay more properly. This is one trend. Another trend, of course, is that the court tends to judge the cases using the proportionality test, here applying the German technique of 3 steps as well. And the common critics here for our court is the very general use, not being very consistent in justificating the application of this proportionality test, and of course a very common use of the what we say Untermaßverbot, the prohibition of insufficient protection. This is also a trend we can observe in our court. I will now finish showing some tendencies, summing up some tendencies we can observe in the last 18 months. what in respect to our Federal Supreme Court's jurisprudence. First, of course, the important role in handling with our cooperative federalism and, of course, assuring the states and municipalities to act even with omissions from our federal government. Another important aspect we can underline is that the Federal Supreme Court strengthened clearly the objective and collective dimension of the right to health and fundamental rights without excluding individual claims, but giving priority to collective action. This is important, not because our litigation in the health system is very focused on individual claims, and this changed a lot during the pandemics. Another important set of decisions of our Federal Supreme Court has shown more deference to scientific evidence, criteria, and statistics, including some cases in which the court has used a proportionality test. This is also to welcome, in my opinion. A general tendency, at least, one can discuss one or other case, but the general tendency to reinforce the protection of vulnerable groups during the pandemics, indigenous people, specific groups of Afro descendants, people in prison and custody, women, etc., can also be observed. Due to the increasing deliberate disinformation, as I said, besides, of course, granting full free speech, the court started to react to this phenomenon. And finally, three other developments, they are important maybe for a comparison. Our Federal Supreme Court started to invest, to use more structural measures, including ways of institutional dialogue and social control, even public hearings in some cases is being decided by the court. And I think this set of developments we can here, I think, sustain is that in spite some critics are consistent, the way the court uses some criteria like proportionality test and others, the court has played an important role protecting fundamental rights, settling federative disputes, and even being an arena for public debate and a laboratory for innovation. I thank you so much for your attention. Maybe Professor Oliver Lepsius can reply something I have said, probably wrong, related to the German scene. And I hope that my remarks have at least put some light for the comparative perspective, not having said, in fact, something really new. So I thank you so much. And while Professor Oliver Lepsius may reply, I can look by email and see if you have some other questions. Thank you so much.
Thank you so much, Professor Zalet, for these very interesting comparative perspectives on Professor Lepsius' talk. I mean, we are already very much behind the time. That's why I propose we still have two public questions. Should we take them up? And then we should come to a conclusion, because we also have interpreters who are working already the whole time. So I propose we briefly address the two questions that we have in the chat before closing the session. The first question is on the balancing the right to work and limiting the movement of people. Would there be ways to reconcile both values considering local situations? And finally, there's a question referring to the falsification of vaccination passports in Bavaria, and how and whether restrictions of civil rights affected the behavior of German people, whether it changed the perception of freedom, whether there are maybe even cultural changes. So Oliver, if you briefly want to address these two questions.
Yes, thank you. Fundamental issues May I just briefly say something to Professor Zahlet's comments, which I found very insightful. What really strikes me in comparative law is how, at least that's how I realize it, how much more successful the Brazilian Constitutional Court is in closely elaborating standards for the protection of health, and in bringing the protection of health into scope of judicial review. So in Germany, the protection of health is an important civil right in the Constitution. However, there is only very limited caseload. So we don't know very much from previous court decisions on the level of protection. The bearer of the civil right, is that a social right or is it an individual right? All that remains pretty unclear in Germany. And we realize now that something is lacking in order to answer the precise legal issues now in the pandemic. And perhaps Brazil is more fit in that way because there is obviously more case law already addressing these issues. That I found a particularly interesting point in your comment. Thank you very much. Now to the other two questions, the balancing issue is a very, very important issue. And I generally would say that we witnessed a huge amount of insufficient balancing of economic issues with, let's say, equality issues or other social issues. The laws very often were only concerned with economic effects and not with social effects. So when the lawmaker tried to make a balancing, it basically balanced different economic rights or economic rights versus pandemic purposes. And it did not take into account the social effects of economic limitations. I think that is very interesting outcome so far. So I would say in a huge amount of laws, there was no balancing at all as far as social issues were concerned, because the concentration was so much on health on the one side and the economy on the other side, and all the social effects of this relationship did not come into the minds of the lawmakers. And to the second question, that is a major issue as well. So do we redefine freedom in general as something the individual has to, how should I address it? The individual may not rely on a natural freedom, but must do something in order to be granted civil rights. I have the personal obligation, so to say, to get vaccinated in order to still be considered as being a rights protected individual in the society. Those who do not get vaccinated may not use their rights. So that would be a substantial redefinition of freedom. And this is dangerous, of course, because if we start with one case, come on, let's guys get all vaccinated. What's the measure? Is that such a obligation? You should do it. It's a minor obligation. If we start arguing like that, of course there will be no end in putting up further obligations in order to be granted a rights protection afterwards. So I think that there is a threshold issue coming up in this regard. Yes.
Thank you so much. And thank you to all the panelists. I think you deserve a round of applause for this very interesting panel. We went a bit over time, but I think it was justified because of the importance of the issue and the interesting discussion that we had. Thank you for joining us. And before we finish, I would still like to thank those people who are usually in the background, but who were very crucial in making this event happen. Livia Gil Guimarães from the Brazilian Supreme Court, Patrick Wasilczyk from the Institute for Comparative and International Public Law of the University of Münster, Anja Greco-Lorenz and Laura Redondo de Campos from the Brazil Center of the University of Münster, as well as Cristiane Feitosa and Patricia Osoria de Almeida, who diligently interpreted this webinar into Portuguese to make it accessible to a broader audience also in Brazil. Thank you so much for your support, without which this webinar wouldn't have been possible. And with that, I thank all of you. I wish you a nice rest of the day or nice evening, depending on where you are. And I hope that you also will join us for the next webinar. We are still seeing which topic we will take and when exactly it will take place. But considering the interesting discussions we had today, I already look forward to the next version of this webinar between the Brazilian Supreme Court and the University of Münster. Thank you so much.